Hello, and welcome back to Coin Lady channel. Attorney James Murphy, also known as Meta Lawman on Twitter, recently revealed some of his thoughts with his followers. He remarked. He said, stakes just keep getting higher for ruling in SEC, in light of the SEC's recent actions against Binance and Coinbase versus Ripple, citation ended. So I'll give you the complete transcript of his remarks here. And I always find his insights to be valuable. The number of people following him on Twitter has increased considerably recently, and I can see why. He makes some excellent points. However, I should state up front that I do not come from a legal or financial background. Nothing I say or write should be taken as recommendations to purchase or sell any particular security. I'm just a fan who occasionally posts videos to YouTube discussing random crypto-related things for kicks. Thus, this afternoon we get this tweet from Stuart Alderety, Ripple's chief legal officer and top in-house lawyer. We saw the SEC go for the shock and awe tactic this week, he remarked. I continue to put all of my faith in the rule of law, with which I wholeheartedly concur. I'm aware of how difficult this situation has been for everyone here. It hasn't been fun dealing with Kim Jong-Gensler and the rest of the cartoons out there and their constant nonsense. However, no court system, not even in the United States, is without flaws. What I'm saying is that what ought to be done is usually done, or at least something very near to that. Furthermore, it becomes crystal obvious that secondary market transactions are permitted for any existing asset. The asset itself is never the security. I have the utmost faith that the rule of law will ultimately vindicate XRP investors. Time is the only factor involved. Because I'm not a lawyer, though, I'm grateful to the many practitioners in this area who have been sharing their expertise. Although some of you listening are lawyers, I know that's not the majority. And it's hard for the rest of us non-lawyers to draw our own conclusions in the absence of adequate information from the lawyers. So, with regards to the attorney I mentioned at the beginning of the film, James Murphy, he has been receiving a lot of attention on Twitter, social media, and even crypto media. In fact, I discovered 2 articles that share his viewpoint on that site. One such piece was Top Legal Analyst Highlights Impact of Ripple Case on Ongoing Cases Against Coinbase and Binance, which was published by the Crypto Basics website. Ripple case more important than ever, according to Cointelegraph, as exchanges like Binance and Coinbase face regulatory scrutiny from the SEC. Let's not waste any more time and get started. Here's the latest from James Murphy, the Meta lawyer. The stakes for the SEC decision are rising. V-Wave. This is why. The SEC's action against Coinbase and a significant portion of the Binance case would be rendered moot if Judge Torres ruled that XRP tokens trading on secondary marketplaces are not securities. The SEC contends in the Coinbase complaint that 13 of the tokens traded on Coinbase should be classified as securities. As a result, Coinbase is against the law, maintaining an unlicensed brokerage and clearing operation in the securities industry. However, the SEC has no legal standing if those 13 tokens are ruled not to be securities. Listen up, this is a major factor in the final outcome. I mean, come on. Do you get what I was getting at? What gives me hope for the future? It is never the assets themselves that are involved in unlawful securities transactions on secondary markets. In my opinion, the SEC cannot possibly fool anyone. If the SEC's goal was to reduce the use of cryptocurrencies, then they've succeeded. You're doing a terrible thing by acting this way. Arguments like this, which are nonsensical and outside the rule of law, won't help if you think you can stop this thing by talking gibberish. Damn you Muppets. Tony Murphy continues, before getting too excited, it's important to note that a judgment by Judge Torres would not be binding precedent in other instances. Judges in lower courts must adhere to the rulings of the Court of Appeals and the Supreme Court. Okay, so let's take a breather right there. Actually, it is the case. I've said this before on this channel, and I know that Attorney Deaton shares my view that the Supreme Court is the worst possible outcome for this case. Looking at the present Supreme Court, it is clear that the majority of the justices do not support government entities that engage in overreach. The SEC does not have this kind of authority, and Congress has made that abundantly plain. We will have justice in the end, so it doesn't matter if it takes another 3, 4, or 5 years to get there. How much of our life, oh God, will have been wasted as we waited for that? The tragedy lies in that. Therefore, I do not expect that to occur, but we shall see. Another issue is whether or not we will be delayed by appeals even if Ripple is successful in this case. Okay, let me come back to that point. However, let's stick with what Attorney Murphy has to say. Therefore, he reiterates, only the highest courts can bind inferior courts. But here's the intriguing part. The judge assigned to the Coinbase case, Judge Reardon, has only been on the bench for around 6 months. Yes. Even smelled like a brand new judge. It consists mainly of glue and chemicals. However, I detect the fresh judge odor. Now, both Judge Reardon and Judge Torres are assigned to the same court in the heart of Lower Manhattan. Do you get it now? I was in the dark. And this is a fascinating development. So, have a look at this. Says he. Therefore, a halakhic ruling on XRP would not set a precedent. When deciding whether or not XRP is a security, I think Judge Reardon will carefully consider Judge Torres's legal analysis. And I think Judge Reardon would use the same line of thinking in determining whether the 13 tokens mentioned in the Coinbase case are securities. This dynamic is two-sided, of course. The SEC will be overjoyed if Judge Torres determines that XRP tokens traded on secondary markets are securities, and will likely argue that the judges in the Coinbase and Binance cases should adopt Judge Torres' reasoning. Again, I understand that anything is possible, but it would still shock me if it did. Obviously you are. Just consider Judge Torres and the hints that have been dropped in the ridicule of the SEC by judges like Judge Netburn, among others. You must be familiar with all of it then. Judge Torres's willingness to accept all amicus briefs that were requested demonstrates that she gives a hoot about secondary markets. This obviously includes the brief filed by Attorney John Deaton on behalf of some 76,000 XRP holders. Yes. While it is reasonable to expect any judge to do so, her apparent concern for the effect on secondary markets is encouraging. How on earth did she take that information and conclude that the asset is a security and that there are secondary markets for it? Nope, you're all wrong, from your business models to your global network of developers. The insurgents have complete safety. It's just hard to conceive that she would reach that conclusion. I could see how she could conclude that Ripple had technically broken the rules. That doesn't surprise me very much. Even though I don't know for sure, I've been saying that for a long time now, without intending to make any kind of bold claim. I'm simply saying it wouldn't shock me if that turned out to be true. It would surprise me, but I suppose it's possible, if a court ruled that XRP itself is a security. So then, Attorney Murphy goes on to suggest that some disclaimers are in order. First of all, unlike Coinbase, Binance issued its own coin, making the matter more complicated. The Airbnb token. Binance is counting on Judge Torres to decide that XRP sales and issuance by Ripple do not constitute securities offerings. Second, a few disclaimers. If Judge Reardon determines that the 13 listed coins are not securities, the SEC might still argue that Coinbase staking as a service constitutes a securities offering. The SEC's case, however, would be severely compromised otherwise. And so, guys, that's the most crucial element for us, as you know, active participants in the world of crypto in any capacity. I'm sorry to say it. It seems to me that the vast majority of us here are holders, investors, or capitalists. That fits the bill, exactly. Furthermore, that would completely undermine the SEC's argument. This in no way implies that I would agree with you if a conclusion were reached about the staking services. That would be a huge victory for us, but I won't get into it in this video. Finally, Attorney Murphy adds, justices on the same court can and do disagree with one another. Although Judge Reardon has only been on the bench for 6 months, I am certain that she will not disagree with the legal reasoning of her more seasoned colleague in a matter of this magnitude. That makes perfect sense to me. Technically, though, you just never know. Of course, Murphy is the first to admit that this is the most important case in crypto history, but he insists that the new judge hear it. The effects will be felt all throughout the world. Do you have any thoughts? Do you have any idea what's going to happen? He concludes that it will take years for the appeals process to play out regardless of the outcome of the initial court judgments. Meanwhile, more individuals have reason to hope for a significant victory for Ripple in the cryptocurrency market. The XRP army appears to be receiving reinforcements. I mean, it's about time. Therefore, I value Attorney Murphy's input here. Now, he's winding up the scenario by saying that he believes you'll see years of appeals regardless of the court's decision. It's possible he's correct. My guess is no. For example, I am aware that Attorney Hogan has publicly said that he believes the SEC will not appeal if Ripple wins, with the bulk of his reasoning being something along the lines of if the SEC appeals and then loses to a higher court, that is binding. As a result, that's just a big mess. That's exactly what lawyer Hogan had stated. It would throw a wrench in their plans to combat cryptography. The choice therefore becomes whether or not to incur the risk of competing with Ripple. So. Just saying. So, let's see what happens. I heard elsewhere that if the SEC challenges an unfavorable verdict, they would be risking a binding ruling from appeals courts, and so I wrote to you, XP Pen. How about that? Is it something they should bother with? A successful SEC appeal, according to Attorney Murphy, would set a precedent that all judges in the Second Circuit must follow. However, the SEC often appeals unfavorable findings on crucial topics like this one. That's fine then. Interesting, then. In this case, Attorney Murphy disagrees with Attorney Hogan. Obviously, I have no idea, however. I just want this whole ordeal to end. I simply want the thing to come over here already. However, another lawyer named Jesse Haynes replied to him and asked, don't you feel that it's likely that the court will just rule on whether the sale of XRP was a security offering and pass on making a decision regarding secondary market sales and the digital asset itself? For the simple reason that neither of those things were alleged in the complaint. Therefore, his question boils down to whether or not Judge Torres will make a ruling on an issue despite the fact that she was not specifically requested to do so. So it's conceivable, according to Attorney Murphy. That would have the appearance of a library, I suppose. Yes. It would be really disheartening if that turned out to be the case. That would imply that the judge read all the amicus arguments submitted on behalf of the 76,000 more freeholders that Deaton is representing and then responded, okay, got it. But I won't say anything that will help the situation. Oh, please God, I pray so. Indeed, that is a possibility. That would be very disheartening, as it would leave XRP with a lot of unanswered questions. Without that sort of certainty, I would be worried about what might happen, especially in terms of price action. And that's really the gist of the library incident as well. Just the other day, I was discussing this very topic. So, there may be a bright side if that occurs. For this reason, the LBC token, the library credit token at issue in the case, was not addressed by the judge in his or her final judgment against the library. We've reached the remedies phase, but the judge's written decision is still outstanding. A compelling indication that secondary market transactions are not covered by the judge's order was made during the January 2018 hearing on remedies in the library case. So long as we get it super duper, which means we may, in principle, receive some negative news here, it could be like a library case if Judge Torres doesn't address this. Perhaps that means the XRP price will begin to drop. Yes, in theory, that might occur. I'm not making any predictions, but I will say that possibility exists. But even if that occurs, she still has an arsenal of cures at her disposal when you reach to that section. When there is opposition to the remedies section, Judge Torres could address secondary market transactions. I'd rather just get now that I know she anticipates the question. And if I were in her shoes, I'd be thinking, well, let's just knock this out right now by addressing this. Yes, it is what I favor. In all likelihood, that is what I would do. But I'm not here to pass judgment. For the record, I'm not a legal professional. That's roughly what this looks like, then. As for the rest of you, stay tuned. However, it is not lost on me that the stakes keep rising for the entire cryptocurrency industry. What really occurs in the SEC then? The Ripple case is critical. Everyone is listening carefully. Even those who dislike Ripple and XRP. No, I don't give out financial advice. Nothing I say or write should be used as a basis for making financial decisions. Please like and subscribe my channel. See you in the next video. Bye.